The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Our next case is State of North Carolina versus Kinston Charter Academy. I'll note that Justice Berger is recused in this case. We will hear from the appellant.
Good afternoon, Your Honors. Daniel Mosteller on behalf of the state of North Carolina. I'd like to save 10 minutes for rebuttal in response to the cross appeal. Defendant Kinston Charter Academy was a private nonprofit corporation that ran a charter school. In the years leading up to the 2013-2014 school year, its enrollment had been declining. The Department of Public Instruction had repeatedly cited it for financial management problems, and it failed to make various required tax and insurance premium payments. As alleged in the state's complaint, KCA sought to obtain a temporary infusion of cash by reporting to the Department of Public Instruction on April 23, 2013, that it would enroll 366 students for the upcoming school year, even though that figure was unsupported and unreasonable. Kinston Charter received state funds for 366 students based on its report, but its opening day enrollment was only 189 students. KCA surrendered its charter to the Department of Public Instruction shortly after the school year began, and it did not repay any of the more than $300,000 in state funds it received for the 177 students who never enrolled. However, it did pay more than $11,000 in vacation payouts to the school's CEO, Mr. Hall, and his wife. In January 2015, the state auditor issued a report detailing numerous problems with the operations of KCA. She referred several of her findings to law enforcement. Using the North Carolina False Claims Act, which is the tool that the General Assembly unanimously passed in 2009 to combat false or fraudulent claims for payments of state funds, the state brought suit against KCA and Mr. Hall. The state's appeal asked this court to resolve two questions. One, is the state's claim against KCA barred by the state's own sovereign immunity? And two, is KCA a person covered by the North Carolina False Claims Act? To briefly answer both questions before addressing them more in depth, the answer to the first question is that the claim is not barred by sovereign immunity. This court in Turner has already held that public schools cannot defend based on sovereign immunity, and KCA has greater autonomy from the state than does a county or city school board. Indeed, the charter school...
Mr. Mosteller, I hate to interrupt you this early, but I want to make sure I'm following your argument. I understand your point with respect to sovereign immunity. Are you contending, or do you agree that charter schools are entitled to governmental immunity?
The governmental immunity question is not posed by this case. As the case has come up and as the arguments by the defendants are exclusively on sovereign immunity, that's what we're before here on. As noted in our brief, we do not dispute that charter schools may be subject to governmental immunity like public schools, traditional public school systems, or cities and counties. I will note, however, that the False Claim Act claim at issue here, that governmental immunity would not be a defense to that. I think specifically because we're talking about a statutory claim of action. Both this court's decision in Jackson and the Court of Appeals decision in Craig, both cited in our briefs, would render a False Claims Act case not subject to governmental immunity. But as a more general matter, if we were talking about a tort claim, for instance, against a charter school, the state does not disagree that governmental immunity may well be proper in that case. I know the Eastern District in the Yarborough case, which is cited in the briefs, did suggest that governmental immunity in a more traditional tort case might be the correct way to analyze a charter school. So turning back specifically to the sovereign immunity question, however, the Charter School Act, the legislature in the Charter School Act specifically and repeatedly uses the word private to describe the type of corporation that must operate a charter school. In addition, as an independent reason on why sovereign immunity does not apply here, it would be because the sovereign immunity should not be a valid defense when the state itself is the plaintiff. To answer the second question presented briefly, KCA is a person covered by the False Claims Act. This answer is both dictated by the state law sovereign immunity analysis and alternatively because KCA is not an arm of the state under the 11th Amendment immunity analysis. Answering these questions as argued by the state does not threaten the many reputable charter schools that educate more than 100,000 North Carolina students. The amicus briefs filed in this case by various charter schools and charter school organizations demonstrate that the defendants vastly overstate the state's control over charter schools and that it is defendants' position that threatens to disrupt the law. Returning to the first question, as already...
Sorry. I just want to ask you a question you mentioned the amicus briefs, and I'm just curious because I didn't see it in your responsive briefs. Your reaction to the argument that was made that we don't even need to reach sovereign immunity issues because once KCA gave up its charter and returned it to the state, it was no longer a charter school, but was just a private entity. And I'm just curious what your response is to that position.
And Justice Earls, certainly we're aware of the argument. That is obviously not the argument that the state made below or has made in its briefs here. And I will say that the Department of Justice just does not have a position on whether the analysis and the counter analysis that's in KCA's response brief to that, which one is correct. So that's all I will have to say on that issue.
But just to be clear, though, if we were to reach, if we were to reverse the Court of Appeals on the sovereign immunity issue and determine that the charter school did not have sovereign immunity in this False Claims Act case, wouldn't we essentially also be necessarily deciding that it was that you were proceeding against the charter school as a charter school?
I think so. As to what would be the effect of sort of saying that if your question is what would be the effect of saying that the sovereign immunity sort of went away because of them relinquishing.
No, I'm asking a slightly different question. I'm just asking whether, so you've said you don't take any position on whether or not returning the charter changes the status of the entity that the state has sued. And I guess what I'm trying to figure out is it correct that we don't have to decide that in this case?
I think, so I will say, I mean, obviously the two questions presented, the question of sovereign immunity itself and whether it is a person under the False Claim Act are distinct questions. I think as laid out in the state's brief, we believe the analytically correct way to answer the second question on whether it is a person is just by following what the state law sovereign immunity analysis is. I don't want to overstate that. Obviously, the other path, which is consistent with what the federal courts have done, has looked to the 11th Amendment arm of the state test. For the reasons we lay out in the brief, although we think it is correct, that the distinction between what is and isn't a person for purposes of the False Claims Act should follow sort of the dichotomy that the U.S. Supreme Court has set out in its Vermont agency and Cook County cases, that a state is not a person for purposes of the False Claims Act, while a county or municipal kind of entity or school system is. We think the appropriate way to sort of bring that U.S. Supreme Court case law into our state case law is based on our state law sovereign immunity test versus the 11th Amendment federal immunity test, just given that it seems a little analytically odd to bring an 11th Amendment test into state law. That said, certainly in this case, and I think in almost every case, the way whether you go down the purely state law sovereign immunity path to define what a person is, or whether you go down the 11th Amendment path, you come out to the same answers. And the test, as both the test under the state law sovereign immunity and the arm of the state test are extremely similar tests, although they could obviously have different answers in some unique circumstances, but that's not presented here. So going to the...
I'm sorry, I know you want to move on, but I'm intrigued with Justice Earle's question, and I guess maybe another way to state it is there a difference between a private nonprofit that's currently operating a charter school versus a nonprofit private corporation that has ceased to operate a charter school?
Again, I don't know that the state, or I think obviously the question there, I think, is, I mean, it's undisputed that at the time of the allegations at issue here, KCA did have a charter, was operating a charter school. They obviously gave it up after the time of the allegations at issue, but before the state filed suit. And obviously the amici and KCA have different positions on whether that change in status after the conduct occurred would alter the immunity analysis. I mean, I do think that KCA has some fair points about some of the analogies they draw to public official immunity, I think, are reasonable points and questions about whether office holders, after they leave office, if their immunity would cease to exist. But obviously a charter school or a charter corporation, a nonprofit, is different than a public official. So I don't know that that would necessarily implicate that issue. But there are sort of interesting and I think complicated issues involved in whether the immunity could sort of, there's sort of a bursting bubble on the immunity. I think that's an interesting and difficult question. So turning to the four elements that this court's case law has traditionally looked at for purposes of state law sovereign immunity. One, whether an entity is autonomous from state control. Two, whether an entity's activities have statewide application or predominantly local. Three, whether a judgment would be paid out of the state treasury. And four, whether there's been expressed legislative declaration that an entity is an instrumentality of the state. On the first point about autonomy from state control, the state would submit that that is the very point of charter schools, is that the very point of them is to make them more autonomous from the state than are our traditional public school systems. For instance, I'd point the court to General Statute 115-218.15d, which declares that the Board of Directors of charter schools, quote, shall decide matters related to the operation of the school, including budget, curriculum, and operating procedures. No role is dictated there for the state. Additionally, I would focus on the amicus briefs that are, as in one of the headers in the Pinnacle amicus briefs, quote unquote, charter schools are highly autonomous. Finally, I would note that charter schools are certainly more autonomous than the public schools, which, as I've already noted in this court's decision in Turner and subsequent cases, have already held that the traditional public schools get sovereign immunity. Turning to the second factor of statewide application versus predominantly local, the state would submit that this is entirely controlled by Turner. That this court in Turner decided that despite, certainly there's no question that the state has an interest in public education, no question that Leandro and the constitutional provisions do dictate that there is a statewide right to education. But nevertheless, in Turner, this court held that education for purposes of the sovereign immunity analysis was predominantly local. The Fourth Circuit in its Cash decision, a much more recent decision, has held similarly under arm of the state analysis, where this sort of statewide versus local is also a key issue.
Mr. Mosteller, if I understand your colleagues' arguments, they suggest that the decisions applicable to traditional public schools don't apply here because a charter school is entitled to draw its students from anywhere statewide. What's your response to that?
I mean, I think two things. As a practical matter, charter schools are going to have a fairly narrow catchment basin of where students can come from, at least charter schools that operate in a traditional school setting. So for instance, the auditor's report here in the record indicates that students for Kinston charter came from the 3 surrounding counties around Kinston. So I don't know that, how one specific charter school, whether it has a narrow or broader catchment basin than the entire Wake County or Mecklenburg County school system, which are obviously very large geographic counties, is I don't think a clear-cut question. And similarly, I think one other point is just the board of directors of a charter school is only managing that one school. In that sense, it is a very localized. You don't even have, again, Wake County Board of Education is dictating the educational sort of decision-making for a population of 1 million people in central North Carolina. I would say that quite arguably is more statewide. Turning to the third factor of whether a judgment would be paid out of the state treasury, both general statutes 115C-218-20B and 115C-218-105B are crystal clear that judgments against a charter school cannot be and are not debts of the state and will not be obligations of the state. And finally, as to whether there's been an express legislative declaration that the entity is an instrumentality of the state, in General Statute 115C-218-15B, the statute and the legislature have stressed that charter schools shall be operated by private nonprofit corporations. They explicitly put in that word private into the statute of who will operate. I would contrast that with this court's decision in Guthrie, looking at the State Ports Authority, where one of the key factors for this court's opinion in Guthrie was that the legislature had specifically said in the statute that the authority is an instrumentality of the state of North Carolina, and it was also an entity within the Department of Commerce. So I think the contrast between Guthrie, where this court has found an entity as a state agency, and this case are quite.
Mr. Mosteller, what do you make of GS 115C-218.20, which does contain language that uses the expression sovereign immunity in a provision that talks about charter school liability?
So 4 points on that, Your Honor. First, I'd note that the language there is a conditional language of quote unquote any sovereign immunity. And it's the state's position that this was sort of a belt and suspenders effort by the General Assembly when as detailed in the legislative history in the state's brief, this provision was added in very early in the history of charter schools. And it may have been somewhat, there were novel issues.
Does the General Assembly have the authority to decide who does or does not have the right to invoke sovereign immunity if it chooses to?
I don't dispute that. Certainly, and I think Guthrie would suggest yes. If that's sort of if the General Assembly were to say that charter schools were an agency of the state or an instrumentality of the state, I don't know that it would be 100% dispositive, but it's obviously a very important factor in this court sort of sovereign immunity analysis, and also in the somewhat similar 11th Amendment arm of the state analysis. But several other points. I would compare what the General Assembly did in 20A to what it has done with respect to local governments, to county governments, to local school boards, where they don't use that kind of any sovereign immunity conditional language. They explicitly recognize there is governmental immunity and then say it's waived in cases of insurance, which I know those are provisions that this court's much more familiar with in terms of immunity. Third, I would point the court to the legislative history that's referenced in our brief, and particularly the fiscal note that sort of further indicates that when the General Assembly, when this was in the Senate, the General Assembly understood this to be sort of a very conditional, sort of waiving it if any sovereign immunity actually exists. And fourth, I would point this court to the recent footnote 6 in the Fourth Circuit's recent Peltier decision, which reads this provision exactly as the state does. Now, obviously, the question in Peltier is a different question, and the state doesn't take a position on sort of the bottom line outcome in Peltier, but we do think the analysis that the court used in sort of deciding whether that charter school was covered by 1983 at least is relevant in some respects to the question before this court. Briefly turning to the issue of the other issue on why we don't think sovereign immunity applies here is the suit was brought by the state itself, and we point both to condemnation cases of this court and the Court of Appeals in the past on when the state is a plaintiff against other state or local entities. We also point to the United States Supreme Court's case law in the 11th Amendment immunity, where the United States is allowed to bring suit against states, even though private individuals would not. Briefly, just to turn real quick to question 2, and I know we've already sort of discussed this. The question here is again whether the reference to person in General Statute 1-607, the False Claims Act, applies to a charter school corporation. General Statute 12-3 does create a default rule that references to persons in our statute include corporations. And as I was explaining earlier, we believe that is reinforced here by the United States Supreme Court's decisions, particularly in Cook County under the Federal False Claims Act, where the United States Supreme Court has clearly held that entities that do not have 11th Amendment sovereign immunity, such as counties or public school systems, are persons under the Federal False Claims Act.
Counsel, is your main argument concerning the fact that the school does not warrant sovereign immunity protection based upon the inherent aspect of a charter school, or based upon the behavior of the school in this case?
I mean, as I understand this court's sovereign immunity case law, I do think it has to be a categorical. I'm not aware of, and and it's not. So I know there is the case law sort of in the governmental immunity context where you talk about proprietary sort of aspects versus other aspects. I'm not aware in our sovereign immunity case law where that is been made relevant by this court. So at least as I read this court's case law, I do think it has to be a categorical determination about what is about the status of charter school corporations. Although I will certainly say the specific claims here, the False Claim Act case that was brought here is very specific to the misconduct that the auditor found and the state alleged in this complaint. And I would point to the various amicus briefs in this case that would suggest that this is not a case where this is opening up some kind of Pandora's box of lots of liability against charter schools, but that this is an outlier charter school and an outlier case. But for those outlier cases, I do think it is very important, and the legislature's enactment of the False Claims Act made it clear that the legislature does want the Attorney General to be able to go after and recoup misspent or misclaimed state funds. So with that, I will save the remainder of my time for rebuttal.
Hold on for me just one moment. I'll make it brief. By way of an analogy, you're not saying then that you're employing a pierce the corporate veil kind of analysis for us, but merely that based upon the nature of a charter school, it is not entitled to sovereign immunity.
That's correct, Your Honor.
Okay, thank you.
Thank you. We'll hear from the appellee.
Thank you, Your Honor. May it please the court, my name is Amy Savon, and I represent Kinston Charter Academy in this matter. Mr. Hall and I have agreed to split the 30 minutes allotted to our side of the V to 15 minutes apiece, and I'd like to reserve 3 of those minutes on behalf of Kinston Charter for rebuttal. First, I'd like to outline why the state's False Claims Act claim against Kinston Charter should have been dismissed, as found by the Court of Appeals. First, categorically, charter schools are a part of the state and are entitled to sovereign immunity. And there's no waiver of that sovereign immunity in the False Claims Act. Second, even without categorical sovereign immunity, charter school would not fit the definition of what a person is under the.
I apologize for interrupting you this early. You said that there was no waiver. what do you make of the provisions of section 218.20 that require a charter school to purchase insurance?
Yes, there is, that language does indicate that the school board should have insurance, and that any sovereign immunity is waived to the extent of that insurance.
Why is, and this, there's probably something I'm just missing because nobody's brought this up, but assuming that you're required to obtain insurance, why is, at least to the extent of your insurance coverage, sovereign immunity not waived with respect to this claim?
And Your Honor, the as far as any insurance issues being a part of the record, that is not a part of the record that's here. However, just the typical False Claims Act being a type of fraud claim itself would likely, as far as insurance coverage issues, prevent there from being coverage here.
So your understanding is then that this would not be, a claim of this nature would not be covered under that policy?
Just talking generally about insurance coverage issues, that would be my understanding. As far as any specifics, there's nothing in the record regarding that here.
But assuming for purposes of discussion that you have a claim that is subject to insurance coverage, there would be a waiver under the statute, correct?
If there was insurance coverage.
Okay, thank you.
For the actual claimant issue, which is the False Claims Act claim. Second, the charter schools would not be persons under the False Claims Act. And then third, our other issue that we brought before this court was regarding what are the specific requirements of a False Claims Act claim, because it is a fraud claim, and how this claim here, as it's pled, does not meet those standards of what has been determined in other courts to be requirements for a False Claims Act claim. The North Carolina Constitution guarantees public education to the children of the state in both Article 1 and Article 9. And in 1995, the North Carolina legislature expanded these educational opportunities by allowing the creation of charter schools. And these charter schools are created to be, this is important, they're separate from existing public schools, but they are still part of the state and they are still controlled by the state. They're just providing new programs and innovative programs, all designed to help performance and give additional educational opportunities for the children of the state. They fall under the direction of the State Board of Education, and they are not a local governmental entity. They operate, again, independently existing schools, but not independently of the state. The legislature's declaration carries great weight, as this court has said in the Guthrie versus State Ports Authority case. And here, the General Assembly established charter schools and specifically declared them public schools in various places in the statutes. And further, they did this because they noted that the State Board of Education must approve the original members of the boards of directors. They have the authority to grant and supervise the charter schools and to revoke their charters. And they demand full accountability from charter schools for school finances and student performance.
Can I ask you a question about how far this principle that you're urging us to adopt, that is to say, because schooling is a public good and because the charter schools are chartered by the state, that cloaks them with sovereign immunity. Does that, wouldn't that logic then also extend to any entity receiving vouchers? And how far would this principle lead us?
And Your Honor, that principle does have an endpoint, and the endpoint that's clear here, it's a clear endpoint, is because of the charter. A charter is a grant of state power, which would be different than a voucher program where it's just, an entity receiving state funds. Here, they actually apply for and have a detailed charter, and that gets approved. and that gives them a grant of state power. And then also it gives them a mechanism within which they have to operate within in order to keep that charter.
So I believe I'm right that you submitted to us a additional authority letter that referenced our recent decision in the SELC versus North Carolina Railroad case. And so I'm curious how you would distinguish where in that case, fairly similarly, the entity is chartered by the state. In that instance, the railroad's board of directors is actually appointed by the state, and yet we concluded it was not a governmental entity. How could it be then that charter schools are an arm of the government and the North Carolina Railroad is not?
So in that railroad case, as in the Court of Appeals case I cited, within that case, it states in all of those that every analysis is going to be very specific to the entity that's being questioned. And so in the railroad case, while this court looked at that and looked at the private nature of the entity, the fact that the state was just this sole shareholder versus being the actual state itself, and the fact that the railroad actually creates its own revenues. There are a lot of specific distinguishing factors that this court pointed to in saying that the railroad would not be a state entity for purposes of the Public Information Act. And the important takeaway I got from reviewing that case is that this court specifically said it's a totality of the circumstances analysis, at least in looking at, again, for the Public Information Act. And that while both of the state and our briefs look at the Fourth Circuit and the various factors they look at, which are a non-exclusive list of factors, and the state points to some other cases here where this court actually said, well, that's the analysis we do. It's a totality of the circumstances. We think that that court, if it wanted to, you could review this case similarly under a totality of the circumstances analysis, but it would still be looking at those same kind of factors that we point to, both sides point to in their briefs, as far as the control and the autonomy and the relationship with the state. And so
while we're comparing charter schools to other institutions, why would it make sense for the general, you would agree, wouldn't you, that without getting into all the details of the discussion between the amici and you and Mr. Paul about the degree of autonomy of charter schools, you would agree, I suspect, that charter schools have a greater degree of autonomy than local traditional public schools. Would you?
I would say that the autonomy is different. They're each regulated in different ways, where the traditional public school system is regulated in different ways with their standards and as far as how they report to their local school boards. Their charter schools are monitored differently, and that's through the Office of Charter Schools, through whether are they meeting what's actually laid out in their charter and what's laid out in the general statutes.
Initially, the charter school reports to its board, doesn't it?
Yes, it does, but it's also controlled by the divisions within the State Board of Education that are different than how the public schools and the local school boards are controlled.
Why would it make sense for there to be a greater degree of immunity for charter schools than for traditional local public schools?
And that again goes back to the categorization of each. So with local public schools, where they fall within a local school board, which is more akin to a local form of government like a county or city, charter schools differently are given their charter by the state specifically, and their reporting is to the state. So it's how they align in the categorization of how they were created. And we think this categorization was intentional so that charter schools would be monitored in a different way than local schools.
But at least as a practical matter, under your argument, if an employee of a traditional public school engaged in an act that was violative of the False Claims Act and allowed the state to seek relief, the state could proceed in that fashion against an employee or a unit of the traditional local public school system, but it could not, under your argument, do the same thing if the same set of facts occurred in a charter school context. That's at least the way I understand your argument. Why, as a matter of legislative intent, would that make sense?
And again, that actually leads to a different question as to whether under the False Claims Act, would a local school board or, as you said, an employee, would they fall under a definition of person? And we would contend that even if we are not entitled to sovereign immunity, but we are entitled to governmental immunity, that also an entity that gets governmental immunity would not meet the definition of person under the False Claims Act once you look at the spirit and the intent of what the False Claims Act is meant to do.
A traditional local public school system is not immune from claims under the False Claims Act, is it?
That has not been determined under the North Carolina False Claims Act.
Under the federal cases, what's the result is that liability exists, correct?
Under the federal cases, they have determined whether that the issue is whether it falls as being a state actor or whether it falls in being a local government. I still have not seen one addressing a local school board itself, but presumably following that categorization of who is a person under the federal False Claims Act, then you would be right, Justice Urban. But that has not specifically been addressed by the federal circuits as far as my review of the case law. And again, that potentially would not have to be the outcome under what is a person under the state's False Claims Act. And I believe for me to save rebuttal time that I will need to end there. Thank you.
If it pleases the court, my name is Ozzie Lee Hall Jr. I'm a pro se appellant defendant. I served as the CEO and principal of Kinston Charter Academy for about 7 years. The central question before the court as to the individual defendant is whether the Kinston Charter Academy's 2013-14 student enrollment goal is or can be a false statement. And I submit that it cannot, and nor that it is not, and nor can it be as a matter of law. The North Carolina Constitution, Article 9, Section 5, empowers the state board to supervise and administer the free public schools, but subject to the laws enacted by the General Assembly. In 1995, the General Assembly passed the Charter School Act and delegated exclusive authority to the state board to set student enrollment goals in charter schools. The General Assembly subsequently amended the Charter Act 3 times and ultimately specifically taking away the state board's authority over student enrollment goals not exceeding 30% of prior year student enrollment. The General Assembly delegated this exclusive authority, this exclusive sovereign authority, to set student enrollment goals to the charter schools themselves. The real issue before the court is whether the charter school leaders across this state can rely upon the laws passed by the General Assembly authorizing them to set student enrollment goals within the safe harbors of what they refer to as normal growth, or whether the Attorney General, purportedly representing the State Board of Education and private quitan plaintiffs, whether they can second guess the judgments made by charter schools. A superficial analysis of the Charter Act shows that student enrollment goals set in the spring for students who enroll in the fall are goals to work toward, and they are not a promise of future performance. The General Assembly's public policy and law is to encourage and support student enrollment growth in high quality public charter schools, including providing the schools initial funding to facilitate student enrollment growth. The General Assembly, in its wisdom, structured the Charter School Act to grant charters sovereign immunity, a higher degree of protection than the traditional public schools' governmental immunity, because of the important role charters play in the state's educational reform program. The state board is required to report best practices learned from charter schools every year, I think in June or July, to the General Assembly. In the case of Kinston Charter Academy, the record shows that individuals at Department of Public Instruction interfered in Kinston Charter Academy's enrollment just days before the opening of school by its public announcement of its intent to seek revocation of the school's charter during the critical enrollment period. The plaintiff would have you believe that there was no path whatsoever to Kinston Charter Academy enrolling 366 students for the 2013 school year, and this is all based on the Attorney General's subjective opinion. This doesn't meet the plaintiff's burden to show an objectively false statement was made. This court can reject plaintiff's erroneous legal conclusions, which claim that I made a false or fraudulent statement under the court's holding in Sutton v. Duke, where the court says that the court's not required to accept legal conclusions, the plaintiff's legal conclusions, or unwarranted deductions of fact. All the plaintiff's conclusory allegations about decline in enrollment, seeking a temporary cash infusion, or other rhetorical hyperbole did not intrinsically address whether the 366 student enrollment goal was a false or fraudulent statement on April 26, 2013, when it was allegedly made. The law allowed Kinston Charter Academy to make 366 grade K through 8 seats available to public school age children across the state for the 2013-14 school year, and also to receive and expend the initial funding that was provided. The school owned a 52,000 square foot facility, which could hold 366 students, as stated by the State Board and the Department of Public Instruction in the audit report. The Office of the Attorney General seeks to reduce the relationship between the public schools, between public charter schools and the state under the terms that are under the terms of the approved charter to a mere contractor engaged in a commercial relationship with the state. The plaintiff errors in this regard. The North Carolina public charter schools are distinct creatures of the law. The Charter School Act itself clearly defines the intent of the legislature that charter schools, the organizations that operate charter schools, their members, officers, directors, and employees are protected under the doctrine of sovereign immunity. If we look at the record in this case, the record shows that the CEO principal of Kinston Charter Academy was a public official, just as all other charter school officials are, and they are excluded from the term persons under the False Claims Act. The record further shows that there was no false or fraudulent statement made as a matter of law. And I requested this court enter an express statement in its ruling that in this matter, that there was in fact no false statement made. And so with that, I'd like to reserve the remainder of my time and turn it, I guess it goes to the state now. So we will end our comments here unless there's questions. Thank you.
Thank you. Rebuttal from the state.
Thank you, Your Honors. First, just to specify, the state certainly appreciates that Mr. Hall and KCA vigorously deny the allegations in this complaint. But as this case comes before this court, we're here on those questions in the Rule 12 context, where the case is governed by the state's complaint, and the question is whether no set of facts alleged would establish liability. Defendants will obviously have the opportunity to disprove the state allegation in either summary judgment or trial if the court reverses the Court of Appeals decision and remains. Turning to several of the questions that the justices asked of my opponents. First on Justice Earle's question about the North Carolina Railroad case. We do agree that some of the discussion in North Carolina Railroad is potentially relevant, or at least instructive for this case. And particularly, I'd point the court to, I think this is the concluding paragraph, paragraph 43 of the majority opinion. And the two factors that the court opinion there focus on or emphasize are the General Assembly's treating the North Carolina Railroad there consistently as a private corporation, and the state's degree of control over day-to-day operations. Here, given the legislature's use of the word private nonprofit corporation repeatedly in dash 15 B and also in dash 25 B or 25, it seems clear here that the legislature is very intentionally declared this a private corporation that runs a charter school. Similarly, with the degree of operation over day-to-day operations, that largely dovetails into the autonomy factors in discussion of autonomy I was talking about under the state law sovereign immunity analysis. And again, I would point this court to both amicus briefs that were filed that strongly that indicate that there is a great degree of autonomy. I will also note that the amicus briefs talk in detail about how the board of directors of charter schools are set, and those amicus briefs, although it's not entirely apparent on the face of the statute, the amicus briefs make it clear that the state has no role in the choosing or reappointment of members to a board of directors of charter schools, which again is something that, and in fact, makes the charter schools even less linked to the state than in North Carolina Railroad, where the state does have control over the board of directors members. Also turning to the question that Justice Earls asked about sort of what's the endpoint of this analysis, and I think and certainly the state agrees that this sort of functional approach that the plaintiffs, or the defendants here point to in terms of a number of the factors, especially sort of some of the funding factors, the control factors, there isn't a clear endpoint. And for instance, there are a lot of sort of the heartland of False Claims Act is often healthcare fraud, Medicaid fraud. Many contractors who receive a very large percentage, if not the entirety, of their funding from state Medicaid and other health assistance programs. So if this court were to go down the path of a sort of functional approach about who ultimately sort of funds the entity, there could be an enormous number of government, and similarly, DOT contractors, a number of them, I believe, receive substantial portions of their entire funding from the state. I know that my opponents also talked about, sort of pointed to just the physical fact of the charter, and maybe that made some difference. I certainly agree with Justice Earl's point about that being similar to the North Carolina Railroad. I'd also point to the many medical facilities in North Carolina that receive certificates of need, how the difference between a charter and a certificate of need, I think one could if you were going to go down the path of saying that a charter is enough to make something subject to sovereign immunity, I think then potentially a certificate of need would be enough to make something subject to sovereign immunity. And finally,
so just very, very quickly,
yeah.
I'm assuming there's some type of true up provision or true up practice that if a charter school overestimates the number of students, generally it's made up in the next year's allocations. Is that true?
And not only just in the next year, it would actually, and this is detailed in the auditor's report in the record. So here, because Kinston Charter went out of business between when they received their first allotment in July and when they would have received their second allotment in October, had it not gone out of business then, and what would typically, and almost all the time, and this is true, I believe, also of the traditional public schools, if you get to October and the enrollment numbers were too high, then the state does true up it then. So the fraud issue here and the claimant issue here is only possible because the charter school went out of business before that October allotment was made. And then when the state board went to sort of impound or seize Kinston Charter's bank accounts, they found there was no state money left. And there was nothing that they could take out of. I mean, they couldn't sort of do any kind of self-help. And so again, this is the only remedy here. And turning to Justice Irvin's questions and colloquy concerning what would be local government and traditional local school boards under the North Carolina False Claims Act, as again, since the General Assembly explicitly, and I don't know of many, if any, other North Carolina statutes that explicitly call on interpretation to flow from federal law interpretation. Since the General Assembly has explicitly said that that our False Claims Act is to be interpreted to be consistent, and this is 1-616C with federal law. Again, the important thing to look at is U.S. Supreme Court sort of dichotomy in Vermont agency versus Cook County. And again, the Fourth Circuit has then further held that A, arm of the state 11th Amendment analysis is what is called for by the Cook County decision, and B, separately in the Cash decision, the Fourth Circuit has explicitly held that North Carolina local school boards are not arms of the state, do not get 11th Amendment immunity. So I don't think there's any way to read the Fourth Circuit case law except to say that local school system, traditional school systems in North Carolina could be persons under the False Claims Act. And again, we also suggest that the state law sovereign immunity analysis is relevant there.
Thank you, counsel. I appreciate that. We'll hear the rebuttal with regard to the issues that were presented on the conditional petitions for discretionary review that were granted.
Thank you, Your Honor. As Mr. Hall alluded to in his statements, there are some requirements in the False Claims Act that must be addressed. First, since it is a type of fraud claim, it must be pled with particularity. And here, while there is a phone call that's identified in April, it does not meet what would be required under the particularity requirement, and it does not meet what would be required for that to actually be a claim that can be a false claim under the False Claims Act. The other pleading requirement that is discussed in our briefs and has been accepted by most other courts looking at this is that a false claim must be an objective falsehood. And here what we had was an enrollment projection, which was an enrollment goal set by the charter school for the amount of students it hoped to have come fall. And so this was a statement that was a prediction about what the future would be that relies on what third parties decisions are going to be about where their children would go to school. And so this enrollment projection that was made in April could not be a statement that was true or false at the time it was made, because it was a prediction for the future. And therefore it would not meet the objective falsehood requirement because of the time in which it was set. And as noted by Chief Justice Newby, the amount that the school gets initially is an allotment based on what this predicted number is. But in normal circumstances, it does get trued up. And if there was any enrollment number that was optimistic and did not get met, then this would get shored up on whatever additional funding is met in October. And
what are we to make of what are we to make, if at all, as a court, that the projection, high as it was in the face of a history of dwindling numbers as to the student enrollment population, and that indeed when it was time to use the phrase true up, there were no state funds available and the charter had been given up by the school?
Well, as set forth as in the complaint itself, as set forth by the states a number of things that the school was trying to do to reach its enrollment goal. And the prong of the False Claims Act is that there has to be a reckless disregard of the truth, which federal courts have said that's more than gross negligence. So it's way further down the line, because this is a type of fraud claim as to what it needs to be. And so that the claim fails here in part because of it being a projection for future enrollment, and one that the state actually details all of the things that were being done to help meet the goal.
If it's way down the line, again, to use those words as you have just used them, isn't the court bound on a 12B6 motion then as to looking at the allegations to be deemed as true at the pleading stage, that therefore we need to be bound by the view that taken as true, there is enough to go forward?
Well, here it's insufficient because there's no false claim that's actually being pled. Because it was an enrollment projection for the future, there was no false claim that would meet the definition of a claim seeking funds that were false at the time it was met.
Is it your contention that there could never be a false claim cause of action asserted based upon something that amounted to a prediction of what would happen in the future?
Here, Your Honor, it could not be the case as far as these charter schools enrollment goals for two reasons. One, the enrollment goals, as long as they're based off of real numbers, the statutes authorize a 20% increase. And so that 20%.
So your contention is that no matter how realistic or unrealistic the projection may be, that as long as you stay within the statutory limit, there's no way that there could be a false claim cause of action.
If it's based off of true, yes, if it's based off of a true underlying number. In other words, if somebody falsified what their school enrollment was, that would be a different story. But if it's based off the real number of enrollment and you're within that 20%, then yes, Your Honor, we contend that could not be a false claim because that provides a safeguard for both the state and the school that down the line you're not going to have a False Claims Act claim pled against you.
Regardless of the rationality of the claim of the projection, there's no basis whatsoever under any set of circumstances and any set of facts that a projected enrollment figure could violate the False Claims Act.
Your Honor, that would be our position, except as I outlined, if you falsified the underlying number, that would be a different story. I believe I'm in my co-defendant's rebuttal time. Thank you.
If it please the court, I think there's a couple of critical issues that relate specifically to the estimate, the so-called estimate, which is actually a goal, the set. And it's being characterized as an estimate, and the state has relied on Harrison v. Westinghouse Savannah River. And in that case, it is a false certification case where where a subcontractor did not follow the Department of Energy acquisition regulation in setting their estimates. And the main contractor knowingly took that information and passed it on to the Department of Energy. And so this was what's called a false certification claim. Well, in this case of Kinston Charter Academy, the statute actually sets up giving the charter school the authority to enroll up to 20% higher than prior year enrollment. The state itself made the calculation as to the estimate based in the statute to say that, okay, if you have this base number, in this particular case, 305 students, then you can go up to 366 students. And this basically is what's set up in the law. And in terms of how you establish what your enrollment number actually is, the state does not, it's not in general statutes. The state board has no policy procedure. There's no guidance given. There's nothing given to say how you're supposed to do that. So charter schools generally rely on the statute that this is a safe harbor, that you can set an enrollment goal, and then you work toward that goal. So it's not like a prediction of future performance. It is actually a goal that you work and strive toward. And this record shows that Kinston Charter Academy worked toward achieving that goal. So in that sense, this is not a false certification claim, as the state relies on Harrison v. Westinghouse Savannah River. And this is not a case where it's an actual fraud case where you have a situation where the state was billed for, let's say the state was billed for 10 widgets, but only 5 widgets were provided. This is not that kind of a case. This is a case that basically is totally founded upon the Attorney General's subjective opinion that it was unlikely that the school could meet the goal, that it was highly improbable that the school could meet the goal. And all this is a subjective opinion. And if you but it has to be based on an objective falsehood, and there is none here. And then if you look at the structure of the way that the charter schools operated, it's set up so that if what the state has pled, that the school had 189 students, that was the school's ADM, and that's what they pled, then that means that the school had enough students that the state would have owed the school almost an additional $500,000 that it did not collect. And the State Board of Education actually agreed to accept the surrender of the charter. They didn't have to do that. So in terms of looking at the way that this whole thing was done, we really have a situation where Kinston Charter Academy acted as every other charter school in this state acts every year, and actually every other public school in terms of setting its student enrollment goal. And if anything, it would be proper to say that the school fell short of its expectation, or it fell short of its goal. But this is in no way a false or fraudulent statement or some type of fraud on the State Board of Education. It's just not.
Thank you, sir.
Thank you.
Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 45 minutes. God save the state and this honorable court. Thank you, Council.